Start. We have considered the submissions so raised by the appellants with relation to the theory so propounded by them relatable to FIR being anti-timed. The Learned Counsel for the appellants has also sought to argue the issue of FIR being anti-timed, but he could not convince the court as to how and under what circumstances the FIR is anti-timed. Merely on asking the same cannot said to be anti-timed, as for that very purpose chain of events has to be proved so as to contend that the FIR is anti-timed. This court, while delving only the question of anti-timed FIR, finds that the chain of the sequence of the events itself depicts that there is no contradiction or inconsistency in the statements of the prosecution witnesses and the narration of the allegations in the FIR so as to suggest that there is anti-timed FIR, as even otherwise this court finds that the allegation so made in the FIR itself goes to show that at about 7 o'clock in the morning on 15 to 2002 the victim sustained gunshot injuries. Thereafter, he was brought to his house as already discussed above, and after waiting for 20 minutes, he was taken in a jeep to the police station, wherein at 18:10 am the FIR was lodged. It is a matter of common sense that whenever there happens any casualty or any emergent situation occurs, then obviously a distance of 8 kilometers can easily be covered within half an hour, particularly in a rural area during early morning hours. The court further finds that the theory of the FIR being anti-timed as has been engineered by the appellants just in order to save their skin as merely making references to certain facts. There is nothing on record to link anything which could suggest that the FIR is anti-timed, particularly when the chain of events and the sequence itself shows that the injuries were sustained by the injured victim at 7 o'clock in the morning and at 7:30 am after waiting for 20-25 minutes. He was proceeded to police station and at 8:10 am the FIR was lodged, and the fact regarding the death of the deceased at 7 am also finds place in the statement of PW5 Dr. Anil Kumar Gupta. The court further finds that there is nothing to show in the inquest report that the FIR is anti-timed, however, rather the contrary. The inquest report supports the prosecution version. Hence, there is no reason to disbelieve or discard the conclusion drawn by the trial court that the FIR is not anti-timed. FIR in a criminal case and particularly in a murder case is a vital and valuable piece of evidence for the purpose of appreciating the evidence led at the trial. The object of insisting upon prompt lodging of the FIR is to obtain the earliest information regarding the circumstance in which the crime was committed, including the names of the actual culprits and the parts played by them, the weapons, if any, used, as also the names of the eyewitnesses, if any. Delay in lodging the FIR often results in embellishment, which is a creature of an afterthought. On account of delay, the FIR not only gets bereft of the advantage of danger, also creeps in of the introduction of a colored version or exaggerated story with a view to determine whether the FIR was lodged at the time it is alleged to have been recorded. The courts generally look for certain external checks. One of the checks is the receipt of the copy of the FIR called a special report in a murder case by the local magistrate. If this report is received by the magistrate late, it can give rise to an inference that the FIR was not lodged at the time it is alleged to have been recorded.